our request?
Well, I was going to start arguing before you got back, but I thought that might be.
Well, you know, you could have done that and it wouldn't have bothered us at all.
Might have been a better result than I'm going to get.
You never know about these things. Ms. Angie, you may call the next case, please.
Gerrish and McCreary, PC versus Carri Chandler Lane.
Your Honor, I'm Richard Glassman of the Nashville and Shelby County Bar on behalf of the appellant in this case, and I'd like to reserve 5 minutes.
All right, sir. You may proceed.
Let me first give credit to my associate, Brian Garrett. He is the author of all that you read. And for Judge Armstrong's benefit, he is a Duke Law graduate.
Ah, not many of us in Memphis.
That's what he says. He took an unusual route to get to us through Austin, Texas, doing document preparation for a few years and then said he wanted to come back home. This is a case that is very unusual, not the normal type of case that I or my firm would be involved in, but we felt that this young lady, now older than young, deserved a preservation and a protection of her rights. This all started 20 years ago when she, unfortunately, decided that she would steal from the law firm that she worked for. She was arrested. She ultimately pled guilty and spent 18 months in the Shelby County Penal Farm in the Women's Detention Center. She also, at the same time as the criminal proceeding was going, there was a civil suit running on the civil track in Judge Childers' court. That civil suit resulted in a judgment against her and her husband. There was a non-party settlement with a bank where she was depositing the checks and supposedly they were negligent in not observing that she would not be depositing this much money, hundreds of thousands of dollars, when she in fact worked for a law firm as bookkeeper or legal assistant. The trial court in the civil matter found that the husband had ratified the embezzlement by accepting or retaining the benefits of the embezzlement and knowing that they were attained, or certainly should have known that they were attained by fraud. So in 2003, we have her guilty, we have a judgment, and for $632,444. The husband pays $40,000 to settle out. The bank pays $100,000 to settle and not be sued. So what we're dealing with today is 20 years of interest because this young lady got her first job at $10.50 an hour, but continued to work hard and attain earnings and made full restitution for the money that she stole, went back to criminal court, asked to have her probation shortened because the probation was set based upon that she would be paying a little over $1,000 a month. That was granted. So the restitution order says she has fully paid her debt, both to society and to the persons that she stole from. The civil case has been renewed every 10 years in accordance with the law, and we are now dealing with interest on that judgment of some 20 years is what's being sought at this point. There are garnishments being issued. There's one out right now for her paycheck for the outstanding amount of interest, which is huge, over 20 years. And so this $140,000, the $100,000 from the bank and the $40,000 from the husband, makes a large amount when you're dealing with 20 years interest. So we've got, are they joint and severally liable? Is this a case of joint and several liability from the standpoint of there is only one claim for money? That's the amount that was stolen from the law firm. Whether or not the bank negligently overlooked her depositing all these funds, it's still one sum of money. So the one sum of money, if we establish that in the court's mind, then the $100,000 and the $40,000 would both be credits against that. The law is clear, we believe, that even if the tortfeasors are proceeded against separately to judgment, the plaintiff is limited to one satisfaction for the same injury. And we cite the authority in our submissions to the court. Commerce Bank, the appellee points out, is a little bit different because they were not sued. The husband was sued in the proceeding. Commerce Bank paid $100,000, but Mr. Garrett has pointed out to the court case law that says that they, again, whatever amount they pay the bank is a credit because there's only one sum of money. The Gerrish and McCreary law firm suffered only one loss, and that's one sum of money.
Mr. Glassman, how do we know what that one sum of money is? Because if you look at the Appellee's brief, they say that the settlement with the bank was for a loss different from the loss with regard to the judgment against your client. And we don't have the record of the 2003 proceeding, do we?
Not that entire record. We have some of that record. But I can answer your question without that record. There was only one amount that was stolen from Gerrish and McCreary. There's no allegation anywhere that the bank stole money from Gerrish and McCreary, that they took it out of their account or let it be taken out by someone who wasn't authorized. There's only one amount that Gerrish and McCreary is for the practical matter, short. And that's the amount that my client admitted that she took.
And that amount, you say, is the 632. Is that right?
Well, it's the amount that she made restitution for in criminal court. That's the amount that was shown to the criminal court satisfaction as being the amount that she would make restitution for. And she fully paid back that amount and was released from her obligation for restitution.
Well, is that amount 632 or not? Because I don't know, should we rely on what the criminal court judge said the amount was as opposed to the judgment out of circuit court?
Well, they could be, potentially could be two different amounts.
That's what it sounds like. It's two different
It
amounts.
could be. It could be. But we're proceeding under the circuit court proceeding because that's where the garnishments are coming from.
Right.
But the criminal court entered an order that she had made full restitution. What this case is about is the interest of 20 years and whether or not this $40,000 and the $100,000 is a credit as to that amount, whatever that amount is. And I'll be honest with you, I think it would take someone a lot smarter than me to calculate over 20 years to deduct each payment that she made over 20 years in various amounts, various garnishments that were paid by her employers, and then adjust the interest as that number comes down and reapply interest as the years passed. It's a mathematical conundrum. It'll take a person a lot smarter than me to figure that out. But if we know what the amount is, what are the credits? And that's what we're talking about. Is it 40,000, 100,000, just the 40? Is it neither of these? Once we know what those credits are, then Mr. Gowan and I can hire someone to calculate what is the correct amount. But
Aren't you looking at three different wrongs, though? Three different alleged wrongs.
Well,
You've got the bank. That's a contractual breach. They paid money that they weren't supposed to pay. You've got the former husband who did not theoretically steal money. I'm assuming he just acquiesced in whatever. And then you've got your client who actually took the money, correct?
no.
Okay.
You have the bank negligently not observing her and depositing the amount of money, large sums of money, into her account from the law firm. There's only one theft that occurred from.
Was there and I'm sorry, I lost track there, but did the bank get sued?
No,
Okay, so it's just a negotiated settlement.
that's correct. So we don't know, there are no allegations, there is
Okay.
no judgment. But
Because you can go either way there. Breach of contract, negligence, a whole lot of things you could say.
I think negligence would be probably pretty easy, but,
Go ahead and answer the question.
okay, for someone, the bank knowing who she is and where she works and not contacting the law firm that this person has deposited hundreds of thousands of dollars of your money into a different account. And as to the husband, the final judgment in the circuit court did actually say that the husband ratified the embezzlement by accepting or retaining the benefits of the embezzlement, knowing they were attained or certainly should have known that they were attained by fraud. And that is in the record. So he's clearly involved with that same pot of money, let's call it. Now, the bank may be a little bit different, and I acknowledge that when I said that. But there can only be one, there is only one loss. The law firm didn't lose another amount of money because of the bank's action. It's the same money. It's the same money that she took is what the bank would have been liable for under contract or negligence. It's the same amount of money, and the law firm therefore has one loss, and the credits would be back against that one loss. It's not two separate losses.
Okay.
So, what about the failure of the trial court, though, in the 2003 judgment, to say that the judgment as against the husband and the wife was joint and several? I mean, how do we correct that? If, assuming you're correct, that it was just one loss, and the 44 is subsumed in the 632, can we correct that 20 years later?
I don't think you need to correct that judgment. And the answer to your question is I don't think you can correct it 20 years later, but I don't think that has to be corrected. What we're talking about is collection. Can the law firm collect basically more than its actual loss? Because if, in fact, she does not get the credit for the husband's $40,000 and the bank's $100,000, then the law firm will ultimately receive more than what was taken plus interest. So they would actually make money off of her illegal actions and the actions of the bank. It increases the sum of money. And there can be only one pot. There can only be one amount under these circumstances. They're not separate damages that were incurred because of the bank action. They didn't incur another $50,000 because of what the bank did. The amount stayed the same because the checks that she was taking were coming into that bank. It's the same pot. Did I answer your question?
Thank you. You've got your rebuttal time.
Good morning, Your Honors. I'm John Galwin of Bassberry & Sims in Memphis, Tennessee, member of the Memphis Bar. And I represent, this case is so old, the firm has actually changed names as we stand here today. It is Gerrish, Smith, and Tuck. It was Gerrish and McCreary in 2003. And I'll refer to it as Gerrish just to be clear on the record. I am joined today by Alex Agee, who, like Mr. Glassman's colleague on his side, she is responsible for the briefing in the matter, and a fine lawyer and fine native of Dyersburg, Tennessee, as well.
Welcome. And welcome, Mr. Garrett.
Gerrish is a Memphis-based law firm. It may not be well known to the court because of the nature of its practice, but it has a nationwide practice where it advises community banks all across the country, and has been very successful over the years. Had a office up in Nashville as well. This case is one that arose, as was stated, back in 2001, when Gerrish discovered that Carri Lane, now Carri Sellers, had embezzled hundreds of thousands of dollars from Gerrish. She stole the money in several ways, but just to sort of summarize, she primarily would routinely transfer money additional and above the payroll amount into payroll accounts. Some of those payroll accounts she improperly opened herself with forged signatures. And she would then pay herself great amounts from those accounts above and beyond her agreed compensation at the firm. She would write those checks. They would need additional signatures, and she would forge those signatures onto the checks. And she did this routinely over a number of years. And the way she did that was she covered it up by destroying return checks from the bank, and she altered the books and records of the firm, and she made numerous failures to pay the Internal Revenue Service, and the Internal Revenue Service didn't come knocking for quite a while. She destroyed some third-party pieces of mail that came into the firm, and then, was opening these various accounts with forged signature cards to cover all of this up, and thus she got away with it for a long time and was able to steal a substantial sum. The case was a non-jury trial, and I tried it on behalf of Gerrish before Judge Childers, and I know you all are very familiar, I would suspect, with Judge Childers. He was an excellent jurist in my experience, and he put a lot of juries in the box and charged them appropriately. And I will tell you from my experience in this trial that I think this was agonizing for him to have to hear the evidence on a bench trial level. And he made comments in the record about how difficult it was for him to determine Sean Lane's liability in this case, but he did so. And I think what's key factually in this case is what he found. You have the final judgment. You see what the final judgment says. There are two separate paragraphs within the final judgment. He found Ms. Sellers liable for fraud, misrepresentation, and conversion, and awarded Gerrish $632,444.86 against her. And then in a separate paragraph in the same final judgment, he found Sean Lane, her husband at the time, liable for $44,402.66, and that was on the sole count of conversion. Nowhere in that final judgment does it say that the two were jointly and severally liable for either of those amounts, and it is clear that he rendered in separate paragraphs judgments on different counts in different amounts against each of them. But I think what is really significant in the record before this court is Mr. Lane satisfied his judgment by 2005. And there are two orders, one from April of 2005 and one from June of 2005. I cannot tell the court 18 years later why there are two separate orders saying the same thing. But if there were any doubt about what the final judgment was, the 2005 order satisfying Mr. Sean Lane's judgment of $44,402 says as follows, quote, "This order is not intended, nor shall it be construed as having any applicability to the separate judgment entered against the other defendants in this cause, Carri Lane."
Let me ask you,
Yes.
at trial in 2003, what did you prove in terms of the amount embezzled? What was that number?
Excellent question. So the burden of proof was on us as the plaintiff, obviously. And we had evidence of a great amount of theft. And what I was able to prove at trial was the $632,444.86 against Ms. Sellers. We believe there was more theft than that, Your Honor, but that's what I could meet the burden of proof on. In this case, I had the role of putting all of the documents together in binders and basically delivering them to the DA's office and working with the DA on behalf of the victim. And they ended up with a much different number over in criminal court when they ordered restitution. But when I tried the case, I was able to prove the $632,000.
But in criminal court, the number was lower, is that right?
Yes, sir.
Now, the 44,000, tell me about that. Is that subsumed in the 632?
Honestly, Your Honor, the answer is there's nothing in the record to indicate that it was. But here's the, I want to be completely transparent about that fact. What happened is those stolen monies went into a joint account, bank account, shared between Sean and Carri Lane. And so at trial, we had, for example, teller machine receipts where, you know, these two had a combined income of roughly $70,000 a year, household income. And he would go to the teller machine and get a teller, he would get $150 out of the teller machine or whatever, what have you. And on the receipt, it would say, your balance is, you know, $148,000. And Judge Childers saw that evidence and determined that he was liable for $44,000 and change, separate and apart from her. So there's nothing in the record that really answers the question, but Your Honor, it is a fact that the stolen money went into a joint account shared by the married couple.
Is it significant at all? I'm looking at the final judgment, March 17, 2003. And in the ordering part of the Judge Childers' judgment, he finds Ms. Lane guilty, or Ms. Lane owes your client money based on claims of fraud, misrepresentation, and conversion. And then he finds Mr. Lane guilty of conversion and awards a judgment for the $44,000. They both were determined to have committed conversion.
They were, but Ms. Lane also committed fraud. She also committed misrepresentation.
And that's why I assume her judgment was significantly larger. But with that in mind, going back to the question that Judge Armstrong asked, he asked in a different form, but I'll ask you the same question.
Yes, sir.
Is this determination about the credits on these judgments, is it a determination that we can make as a matter of law, or must it be made as a matter of fact before this court considers it? In other words, obviously the trial court could have said this is a joint and several judgment if somebody had asked them back then, or asked the trial court back then. Apparently that question was never posed to the trial court. How do we consider it now? Is it a question of law? Is it a question of fact? And if it's a question of fact, is it too late to even ask the question?
Yes, sir. The answer to your question is it's too late to ask the question. And the reason is it touches on something that is a matter of law, and that is in order for Mr. Glassman to have prevailed on his original motion for outstanding judgment to be deemed satisfied, you would have to have joint and several liability. As Your Honor pointed out, there's nothing in the order, and Judge Childers didn't find joint and several liability. It's not in the record. The complaint didn't ask that the defendants be held jointly and severally liable in this case. So that's not in the record. So as a matter of law, then one has to go back and alter or amend that judgment from 2003 to make it a joint and several liability situation in order for the result to be that the judgment now with $780-something thousand in interest later to be satisfied, right? So what then does the law tell us about the process for that? Well, you have Rule 5904, which would have required that procedure to have been done in 30 days, or you have Rule 60.021, which, did Judge Childers make a mistake in not saying joint and several liability in the order? They would have had a year to do it under that provision. But you can't get to
Then you've got
this.
the 5-year cap. Then you've got the 5-year cap under Rule 62.
Right. And so to get to Rule 60.024, subpart 4, where you can bring a motion within a reasonable time, what's a reasonable time here? It requires that the joint and several liability issue would have been resolved within 30 days, a year, or your 5-year mark, right? That we can't do that now. And therefore, it's untimely, even if the underlying part about 5904 and 60.021 weren't before us. A reasonable amount of time is not the case here, because we're talking about 20 years later, and there's an argument in the brief that, well, there was a garnishment 8 months before the motion. Well, Ms. Lane made payments. They were such small payments that interest accrued more than the payment that was being made, and therefore the amount continued to increase, sort of like a credit card, high-interest credit card in today's environment. And that was the fact that happened over time, but in order for Ms. Lane to have satisfied the judgment at $500 a month with interest accruing, she stops making payments in 2021 because the criminal court, ended her probation and deemed her criminal order restitution paid. And when those payments stopped, my client decided to garnish her paycheck. She makes a good wage or a good salary, and they exercise their right as a judgment creditor to do that. But that's not a trigger that then starts the clock over again in some way. I think that's a non sequitur to come to that conclusion 20 years later and say, well, there was an attempt to collect. And I just want to touch real quickly. I've talked about Sean Lane not being a jointly and severally liable. Commercial Bank and Trust is really not in the record before Your Honor. There's a brief reference to it in a criminal court order that was filed and made part of this record, but there was no mention of Commercial Bank and Trust in this lawsuit. It was not a part of the case. They were not a defendant, and they were not even mentioned in the complaint. And there's nothing in the record that really shows if there was a confidential out-of-court settlement under a depositor agreement with the bank regarding their actions under their contract with their customer and their duties under the UCC, that's not in the record here. And so I just conclude by saying it would be grossly unfair 20 years later to say that this judgment was satisfied because somebody paid $44,000 18 years ago on a judgment against her for $632,000. My time's expired. So.
You said, so the payment by the bank is not in our record at all. Do we
what?
even know what the amount is? Because,
honestly, Your Honor, in looking at the record before this court, the criminal court, and I don't know where they got the information about a confidential settlement. I have no idea where it came from. I wasn't involved in that proceeding in criminal court. But there's a reference to a settlement with Commercial Bank and Trust. in that criminal court order. It's not
Yeah,
in
and I
this
think they
case.
indicate that the payment amount was $140,000. But let me ask you
Yeah.
this, is that payment, is that somehow different from the amount, I know it's different in terms of numbers, was that because of the amount embezzled? Or was it for something different, a different loss? Because we have this rule about, one loss, one recovery. You don't have one loss and get double, triple recoveries unless there's some statute that provides for it.
Yes, it was a different claim completely. The settlement with the bank, and again, it's a confidential settlement. If ordered by a court, I guess my client could have provided further information on it, but it's not in the record. But that would have arisen from a breach of the depositor agreement between the bank and the bank customer, and any duties that would have arisen on the part of the bank under the Uniform Commercial Code in terms of the accounts that were open. But keep in mind, Your Honor, again, I was able to prove $630-something thousand against her at trial. That doesn't mean that the whole universe of what was stolen from Gerrish is that amount. That's what we were able forensically to go back with an accountant and say, here's what we came up with that we can, in black and white on pieces of paper, show Your Honor that we proved against her.
Thank you.
Thanks.
Two things, real quick. They can't go over what they got the judgment for in circuit court. They can't now reopen that case. That case has been over for 20 years. There are two orders, and they're in this record, from the circuit court action, where an order is entered in the action in which my client was sued, and it is signed by the judge, and it is signed by a lawyer for the law firm, and it is signed by my client's husband, but there's no signature for her lawyer, or a certificate of service on that order.
Which order are you talking about?
This is an order of order of judgment satisfied by the husband. She had no notice of what was going on. And there's another order also that's the same thing. There's no place for her signature, her lawyer, or a certificate of service. Just her husband's lawyer and the bank's lawyer. So is this a question of law or a question of fact? I submit it as a question of law under 60.024, which deals with relief from a judgment if the judgment has been satisfied. And in this case, we allege that the judgment has been satisfied, or at least substantially satisfied, depending upon the credits of the $100,000 or the $44,000. The $100,000 is referenced in the criminal court order, which is part of this record, as monies received by the law firm from the bank. And it is the same loss. The law firm didn't allege, it would be impossible to allege that they had a separate loss that they suffered, separate and apart from the money she took from the firm and put into these fake accounts, deposited into this bank.
It's a totally different number though, isn't it?
Well, they agreed to a number. It wasn't tried.
No, I'm talking about in the criminal court. Aren't we looking at two separate numbers?
Yes.
It's the same, it results from the same conduct, but the criminal court litigation has a $1 figure. The civil court litigation has a different dollar figure.
Right. There's no question. And some of the people in this room today, 20 years ago, were 8 years old, 5 years old. I was not involved then. I didn't get involved until 2021. The criminal court was handled, of course, by the prosecutor, and the civil suit was handled by counsel here. So, but there is an issue here, not of fact, but of an application of law as to whether or not this satisfied or partially satisfied judgment, depending upon whether you look at the criminal court amount or you look at the amount coming out of Judge Childers' court. Now, so we think we are here under 60.024, and it is a question of law, of the satisfaction of the judgment and relief from that judgment under 60.024. Now, the husband in the judgment order entered by Judge Childers, as to the husband, says, he ratified the embezzlement by accepting or retaining the benefits of the embezzlement, knowing that they were attained or certainly should have known that they were attained by fraud. That's part of that order that's in this record as to the $44,000. Also, if your honors would take a look at the P&C case that we cite in our brief, it says clearly that he, the husband, would be considered a joint tortfeasor. If you also look at the estate of Link case that we cite in our submission, applying the doctrine of joint and several liability to a defendant and a non-party when the plaintiff had brought suit against the non-party and received a default judgment in a separate action. The court says there is no requirement that defendants be sued together in order for joint and several liability to apply. But, as Judge Armstrong said, old habits are hard to break.
Yeah.
Plaintiff can have but one satisfaction for the same injury, and a satisfaction from one will preclude him from proceeding against the other defendants. And that's the State of Link case that we cite in our submission. So we say that there is no doubt as to the husband, as to the bank. We have not been able to see the settlement agreement, but the criminal court does make reference to the $100,000 as a payment made because as a result of the embezzlement. So we consider it as one loss. Thank you.
Thank you. Thank you, counsel. We certainly appreciate your argument. We'll take this matter under advisement, review the record, and attempt to render a judgment or an opinion at the earliest possible time. Thank you. You may be excused.